Welcome to the HealthLaw HotSpot. HealthLaw HotSpot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the HealthLaw HotSpot. I'm Erica Adler, shareholder and leader of our healthcare practice at Retzel & Andrus. Today, I'm joined by Leslee Cohen. Leslee is a corporate and securities lawyer based in Chicago who focuses on representing startups and growth stage companies in connection with their seed round fundraising and day-to-day contract needs. After attending University of Michigan undergrad and NYU Law School, she worked in New York representing large publicly traded companies on Wall Street. And eventually she moved to Chicago and co-founded her own firm where she works today. And today, we're going to talk about some of the work that she's doing in her firm, which is called All Rise Legal Counsel. And we're going to talk about some of the work that she's doing with some of these startup companies and how my healthcare clients, as well as Leslee's, can really benefit from understanding the work that Leslee does in helping these early stage fundraising efforts really work. So kind of want to understand a little bit or explain a little bit about where I'm going with my interest in having this conversation today. We have a lot of clients who they may be doctors, maybe dentists, they may be other people related to healthcare, but they often have a lot of great ideas. They may be starting up a company that's going to do telemedicine. They may be starting up a company based on an app or a device or something they created. And very recently, we're working with a ton of clients who are really creating their own management service organizations, MSOs, or dental service organizations, DSOs, to buy up practices and to really compete with some of those private equity companies out there, often maybe with the goal of growing big enough to be acquired by a private equity company. So I see this topic of needing to raise funding being really important in healthcare, particularly with smaller businesses and smaller practices, and even some of my solo clients. This is something they really need and want to know more about. So Leslee, thank you so much for joining me today.
Thank you for having me.
And thanks so much because this is a really interesting topic. So why don't we start off by having you describe a little bit about kind of what you do in terms of your work with these startup type companies.
Sure. So typically companies find me in one of two times sort of down their road of life. One would be we haven't formed an entity yet, and there's a group of us, and we have this app idea, and we want to know, should we be an LLC? Should we be a C Corp? Why not? How should we divvy up equity between us? Who should own what? What kinds of agreements do we need between us? What if we have some advisors who have been really helpful along the way and we want to give them some equity in the business? How do we structure that? So that's kind of number one. And number two is we've done all that stuff. We're around, we're existing, we've bootstrapped till now, and we're ready to raise funds. And how do we do that? Are we selling stock to people? How do we value the company for that purpose? So one of those two places, and we take clients through that process.
So when somebody comes to you and they have an idea and they already have their people that they want to be investors, that's probably a little easier because you kind of work with them on that term. Do you help connect companies with potential investors, or is that not something you get involved with?
I do. I have a stable of investors in for these purposes in the healthcare space. A lot of healthcare tech investors who, I certainly can't guarantee anyone would be interested in particular, but I do have a good, 20 different potential investors who, and typically these are high net worth individuals or family offices who just are interested in kind of diversifying their investments and putting money into something sort of different.
So when you meet with these kind of clients and you're talking about how to bring in these investors, are there sometimes ideas that they come in with that are just totally incorrect that you feel you need to, correct them of their misunderstanding that are fairly common, that, some of the people listening today would maybe have those ideas in their mind and also need to be corrected on how they're thinking about it. Do you know what I mean?
I do. Yeah. I mean, first of all, I get the, I'm going to be the next Facebook. We're going public next year. No, you're not. Building a startup is a huge amount of time and effort, and they so commonly fail. And there's so much that goes into doing it right, that it's just not that simple of, we're going to come in and storm the market and take it over. So that's one sort of misconception. And then, I guess another one is, I don't need an agreement with my co-founder because we've been partners in our medical practice for, 20 years and it's going so well, and I don't have to worry about anything. I guess, also maybe making sure to protect the intellectual property that you develop. So, again, we've been practicing medicine together forever. We developed this app together. We don't need a separate entity, to contribute that to that IP that we've developed to. Those are some of the top things that come to mind.
Right. So having kind of a realistic time frame is really important. Then knowing like, this is what we're going to achieve this year, then we're going to do that. Do clients, from what you're saying, they often want things to happen faster than realistically. How long does it generally take, when somebody has an idea to really where you're seeing that they've got the funding and they're kind of moving towards success? Is that a kind of a 5-year time frame, or is that not even realistic?
No, I think 5 years is very realistic. I mean, first of all, which more about than I do, there's the FDA approval, in there. So, if that's a factor, that can certainly add a number of years to the process. Short of that, if it's more of an app type of thing, it's usually from, okay, we're ready to raise funds. It's probably about a year till you actually are going to close on an investment. And we're talking about like $1 million or under, not huge dollars.
Right.
But really just, yeah, go on.
No, I totally get that. I find one of the frustrating things is sometimes clients do not have a clear idea before they get started of what they want to do. So they kind of tell you what they want and you start working on it. And then next year they're like, oh, we want to replace this guy with that guy. Or I told so-and-so they could have X percentage of it. And it becomes really messy. What advice do you usually give to clients in terms of, and by the way, that can get very expensive if documents need to be changed and stuff like that. Well, what advice do you like to give to clients about, how you make those decisions and how you handle them in the documents?
Well, one thing is in the documents. That's the key thing you said, which is, have documents, use a lawyer. And, I used to hear that and think when lawyers would say that, I would think like, that's so salesy, but the truth is, I mean, I am working on 3 different clients in my office right now that it is costing $10,000 and up to clean up the messes of an email that went out. Oh, you can have 1%. You've been so great. You can have 1% of my equity. You can, and no documentation, oral agreements. And then you've got a few problems, mostly investors. When, clients come to me and they're like, okay, we've got these 5 investors interested and they want to do due diligence. And they want to know, like, what does the structure look like? And then they dig into like some possible, what could go wrong in the future with our investment. And they find, oh, you promised someone stock and then you had a big argument with them and they just went away and you don't have any documentation whatsoever as to that they released the company. And who knows if you become successful and they come around 10 years from now and say, hello, I own 50% of that. And then the investor's money is going to litigation. So, so important to document everything up front.
I think that's important. And often it's funny, you can ask these questions time and time again, and they're just like, no, there's nobody out there. No, I never said that or whatever. And then it pops up a little bit later. So, we can only do our best based on what we're told. And, clients who have very casual relationships or shoot off casual emails get everybody in trouble. You got to be business minded. You got to think of it as a business. And often I find it's not a great idea to necessarily choose as your business partners, family members or, people that you're friends with, because your relationship is not business-like, and it can be very hard to think, businessy. You don't give preferential treatment to family members over investors. You want to like treat people differently, which can be really difficult as well. I don't know if you've seen problems arise like that. I often talk with clients who use their one entity for a variety of different things. And I have to convince them that you really need to pursue this business in its own entity, where we have to like break it off. So for example, if you have a medical practice and then you want to kind of develop a telemedicine business, let's say, those can be very different things. And you can't bring, especially in Illinois or any other state that has corporate practice of medicine, you can't bring investors into a medical practice or a dental practice or a licensed business, right? So, but a lot of times they've gotten pretty far down the road and they've done it incorrectly. I always try and tell them, look, talk to a lawyer very early on when you have an idea, because we can save you so much time and money. Do you often find people try to run multiple businesses out of a single entity that you have to split up? Is that an issue that you come across?
I've come across it, and I think that's what I mentioned before, how important it is to have those be separate. And again, back to that, using a lawyer from the beginning, spinning off one business into a separate entity, which is important for so many reasons, to separate the liabilities. And then also because investors want to know exactly what they're investing in. And if you have two different businesses, you don't necessarily want an investor to have part of both of them. I mean, maybe that you want to protect one idea and have that be kind of separate. What if you want to sell? You get an offer from, someone to buy one piece of your business. You want to have it in a separate entity. So, it's really important to keep them separate. And I have certainly had to do like a spin out of one business out of one entity into its own. And that's expensive. So, again, back to that, like, plan accordingly before you, right at the beginning.
Right. So when sometimes in healthcare, for example, I mentioned the MSO or DSO, you might have somebody buying up practices and you might have those practices continuing operating at different locations. And I don't know, how often you see this in other industries, but definitely in healthcare, we see that. And let's say you have a doctor, dentist working in one of the practice, but he or she is not an owner of that management entity, but you're like, hey, you've done such a great job. I'd like to give you a piece of it, but only as it relates to that location or, that piece of the business. Do you see this coming up? We have done it in a way where we often will create like a new class of stock or new class of membership and allow somebody to participate on a non-voting basis in that particular subset. But how common is this in what you're seeing, and how does it affect, investors' interest in being a part of something that's broken up in that way? I don't know if you've come across that.
Yeah, I mean, so typically, I would keep that in one. I would separate out the entities. I think it gets really complex to have someone own like let's say a profit share from one division of the business. So, I wouldn't typically recommend that. I mean, that may be totally different in the healthcare world, like amongst doctors. But if we're talking about amongst, doctors or, healthcare providers who start a separate business, I would typically keep it under in one entity, or break out the entities rather than into separate full entities, rather than giving people like a share of a division of the business, let's say. But yes, I agree, non-voting interest. And then the other thing you can do is phantom equity. And that's pretty common. And there's two kinds. There's just profits interests, where sort of akin, well, very much akin to non-voting equity, where you're not a member, let's say of the LLC, but you have the right to the economic benefits of X% membership. And then there's phantom stock, which is you set the valuation of the entity at whatever this you're trying to incentivize this employee, right, to give them a little equity. And so you peg the value of the company on the date of grant. And then if you sell that business in the future, the recipient, so that advisor or employee that got the phantom equity gets, like, let's say they have 5%, they get 5% of the increase in value from the date of grant to the sale. And I like that a lot, because there have been arguments that profits interest can be really that those people are really members, and you're trying to rob them of their rights to examine your books and records and that type of thing. So, I mean, some courts have decided that. So I like phantom as a kind of differentiator.
I like that too. Do you find that when you're trying to bring in investors, though, that they're not interested when you have all these different arrangements out there? Or do you think, with full disclosure, it doesn't turn them off?
With full disclosure, it doesn't turn them off. They don't like when you have a crazy long cap table. Like I have some clients who have done the crowdfunding and have 100 and something investors, and institutional investors in general stay really far away from that. They don't like when your cap table has 100 and something people on it. But if it's incentivizing some providers with equity, they're fine with that.
Right. And what about, one of the problems I have is we get a company up and running, and, but the people who started it, let's say they're doctors or they're dentists, are not really used to running a business, and they don't maintain the proprieties, and they're kind of a little bit messy. They make side deals, and I find that kind of usually concerns me, because even though you set someone up properly, once they're set up and they're running, you're not checking on them every single day, right? Have you come across any problems where people have just kind of taken the perfectly established organization, you did their books and records, everything was fine, and have things like fallen apart, or have they done or made missteps that have kind of really impacted the company in terms of their relationship with their investors, their ability to sell, their ability to operate, or gotten themselves into trouble at all?
I mean, most startups fail, and for a good reason, and that's part of it. Usually I have found that once they see the value that we add and how careful they have to be and what could go wrong, from there on, they usually contact me with everything. Although I will say, I've seen a lot of granting. Oh, I'll tell you one. I just thought of one big one, which I've run into a bunch of times. So I'll do option grant agreements for companies, and you have to set the exercise price of the stock option at whatever the value is of the company on the date of grant. So in the beginning, it's almost nothing, right? So I'll do a form document, and the first few recipients of options, the exercise price is, let's say, like $1 a share. And then the company keeps using that agreement, and they forget that the value has increased dramatically. And it's called a 409A issue, and it can lead to huge fines from the IRS. And I recently had a company exit, and they had done that. They hadn't told me that they had issued all these options, and they took a huge hit to the price that the buyer was willing to pay for the company because of this potential liability out there. Like, what if the IRS discovered this? It was a big problem.
Yeah, I mean, we come across, I have done documents for a client, and then, we do them and we're like, did you get them signed, whatever. And sometimes clients just disappear. I don't know if you've had that, but sometimes you just don't hear from them. Once in a while they're like, hey, how you doing? But we're not involved with the documents anymore, and they don't want us involved. Sometimes they just want you to do the documents. And then, a year later, 2 years later, they'll ask you a question and they'll say, well, here are the documents, just so you could take a peek at them. And I see that they've either amended the documents on their own, or they totally rewrote them on their own, and they no longer match what I had done. And I don't necessarily do securities work like you do, but we do shareholders agreements and operating agreements and stuff like that. So even those kind of changes can make a big difference. And I guess I think you need to be really careful. If it's your parents that are your investors, that's one thing. But where you have a company that's investing, or you have strangers that have invested in your concept, and you're loose like that with your documents, I mean, I see a lot of potential liability happening under those circumstances.
A lot of potential liability. I actually had a client who was, I thought, fairly sophisticated, and he called me. He said, my dad in India got into some debt, and so I sent the money over to my dad, but he signed a promissory note. He'll pay me back. I'm like, you can't use investors' money to pay your dad's debts. Look, I mean, that's fraud, And so I actually resigned as counsel because I was panic stricken to be, involved in anything like that. But yeah, it's really important. And yes, to your point, people all the time, clients will just add a provision, because they'll send out a contract to someone and they'll say, yeah, I'm good with that, except can you add this? And they don't run it by us. And then, trouble ensues, and then they send it right back to us and say, uh-oh, what do I do? And the first thing, you don't realize that they made the change on their own. And the first thing I do is panic, like, how did I let that happen? I would never make a mistake like this. I don't think and then I'm like, okay, I didn't do this. They took it upon themselves to do so. So yeah,
Right.
Big problem.
And I always am surprised that they paid to have documents done, and then they either replaced them or modified them or cut and pasted and did whatever they needed to do. So one thing I just want to kind of wrap up on here when we're talking is, if somebody is interested in starting a business, A, we've already said you got to talk to a lawyer. B, you need documents. The kind of documents you need depend on the deal, right? But one of the things I really want to hit on are, what are the key points of what needs to be in these documents? And I'll just throw off, like, number one thing that I worry about is, obviously, how do you leave the arrangement if you want to leave, right? Especially if you're kind of a startup closely held and you're trying to bring in investors, but people come and go, they die, they this and that. I find that one of the things that's very often lacking in terms of the conversations people have had is, what happens if I just want to leave? How do I leave? How much notice do I have to give? Can I leave? Right? What are the penalties if I leave? Like that kind of thing. And then what happens in the event of like a death or a total disability? For smaller companies where you have just a couple of people, those are really key issues. Would you agree? And then what other points do you think are super important that people need to talk about as they're entering into these relationships?
Yeah. So one thing to deal with the leaving, and this is, investors want to see it, and it's also really protective of the founders, is the founders' shares should vest over time. And what that means is that for a period of time, yes, you have your shares in the company that you formed, but those shares are subject to forfeiture if you don't stick around. So typically what I say is, or what's market is, after 1 year, 25% of your shares vest or become yours. And if you leave the company, they go with you. And then it's usually a 4-year vesting period. So 25% up after a year, which is called a cliff. And then in equal monthly amounts for the next 36 months. And so that's step one of making sure, incentivizing people to stick around. And allowing for the fact that they may not want to. And so they just give up their equity to the extent that it's not vested. And then step two is to have a founders agreement or shareholders agreement or LLC operating agreement amongst all the equity holders. And so a couple of things. One is, yes, upon, death or disability, there you have in there, the company has a right, and or the other shareholders have a right to buy back that stock. But what you touched on is really important. I always put something in there about termination of business relationship as well, and make sure that if someone is leaving the company, whether on their own or, they're just not pulling their weight and you want to fire them, terminate them, that you have a mechanism there for the company to buy back that stock, probably at fair market value because it's vested. They've earned it. They've done some work to earn it, but must have something in there. And I'll tell you, that was 10 years ago, my very first startup. The kind of, there's a few sites that have documents that we all sort of use and as starting positions. And the documents that I was using did not have a provision for that termination of business relationship buyback in there. And this client, wonderful guy, brought on a salesperson and, thought she was God's gift to the world. And she, gave her 10% of his company and vested over time. First year went great. So 25% of her shares vest. And then she did something terrible and he had to fire her. And she walked away with 25% of his stock with no means of getting it back. And she proceeded to come to every single annual meeting. Now, typically annual meetings don't even, you just document them with a written consent. Well, he had to hold a meeting because he had to give notice to her. And she would always say, yes, I'm coming. And they'd have to hold an annual meeting and she would show up and, harangue him like, why did you do this? And why did you not do this? And why did you sign this contract? And make him crazy. So, yeah, really important to have that agreement.
I often see agreements where you can't leave no matter what, unless everybody agrees to let you out. You know what I mean?
Yeah.
So you could literally
more typically in an LLC.
People who have stuck there forever and you can't get rid of them. That is often an issue that we face. Right.
Yeah. And then I'll tell you one other thing, because you said, anything else you can think of, when the disclosure that you're giving to investors. So, you can't just print out you can, but, just print out a form of convertible note or what we call a SAFE, which is a very common early stage company fundraising mechanism. If you just print those out and give them to your investor to sign, you have potential liability under the securities laws. You have to tell people your potential investors, what a reasonable person would want to know in deciding whether or not to invest in your company. And by doing that, having a set of risk factors, like a purchase agreement and risk factors, it's your insurance policy that if someone decides to come back and sue you, no lawyer is going to take the case because they're going to see this and say, like, you signed something saying, you invested in a startup and that there was a really good chance that you were going to lose your money. And there's no cause of action here.
Right. I think that's really important. We see that obviously in more formal arrangements. A lot of times when people are just kind of doing business with friends and family members, they tend to skip that step, which obviously, may not be a great idea because at least with, friends, they may not be friends down the road. And they may say, you never told me about this risk, right? This wasn't disclosed to me. Family member, I guess they could do that as well, but it may be a little bit less likely, right? But certainly strangers, you want to make them aware of the potential risks of doing anything, right?
Absolutely.
I think that's really important. What I'm seeing really is a lot of people involved in healthcare in terms of practicing medicine, dentistry, other types of specialties, dipping their toes now more and more often in the business world. And whereas when you're just a group of doctors doing business together, we have an operating agreement, Cheryl's agreement is kind of, it's casual, but where you're really going to go out there and create a company that you hope to bring in outside investors on, or hope one day to sell to a third party, you got to really think of it in a very different way. And, there are lots of formalities that need to be, taken, when you're bringing in outside money and funding. And that's why I think it's so interesting. Your perspective on this is much more formal than the perspective that I have when I'm working with my clients who, this is just an offshoot of what they're doing. So we're kind of casually going into it, but there really are some formalities that should be followed to get this done right. I think that's super helpful. Now, can you think of any kind of, I guess, I mean, you've already shared quite a few, but any red flags or warnings that you have where you think people should not proceed, whether it's the relationship with a particular investor or just any kind of, red flags that you've seen where you would be like, this is not going to end well?
Well, one red flag in general, I would say, is be careful about having non-accredited investors. And that means someone with, so accredited investors have $200,000 in income for the last 2 years with an expectation of the same this year, or 300,000 with their spouse, or a net worth of $1 million exclusive of their principal residence. And there are there's some other family offices. There's some other categories, but those are the general. People very often will say, well, yeah, I'm going to take 10,000 from my sister and 5,000 from my uncle. And, are they accredited? No. And there's a much higher disclosure responsibility on the part of the company when it comes to taking money from those kind of people. And so institutional investors, for like, let's say you make it and you want to raise big money later on, they don't like to see non-accredited investors on the cap table. Now, if you have no choice and that's the only way you're going to get funded, of course, but that's one thing I would look out for. I like strategic investors who care and who, I'd rather that, and that's why most of my investor contacts are like one-off people who are interested. So I've got, like, in the healthcare industry, like 6 people who know what they're doing in the industry and want to invest specifically in startups in that industry because they can bring contacts, they can bring expertise, they care. And I like that much better. I've seen when it's just an investor who's in it to make money, which, I mean, everybody is to some extent, but like where they have nothing to bring to the table. All they want is for you to make money for them. And like, you go into the relationship and it's all lovey-dovey, but if you don't hit your numbers, it's not staying that way. And it's going to be a really big problem. And it's not only like, financially expensive and challenging, it's emotionally awful to go through, and time consuming. So that's the other thing I would say.
And then one last question is, how does somebody, getting divorced impact this? Because I've had an issue previously where I have a guy who was offered an option to invest in a company, and he never exercised it, really. I think it still was in place, like the option existed, but he hadn't exercised it. And then he was going through a divorce, and our client was just being made crazy by the divorce lawyer in terms of producing documents, getting deposed and all that. Have you seen that happen? Is there really any kind of way to prevent that?
I have seen that happen. I think, it is a hard thing to prevent. I think, putting the investment in the name of a single person and having a lot of times our documents have spousal consents where there's a 1-page attachment that the spouse has to sign, that they understand they're signing off on the terms of the option. And maybe in that situation as an investor, you want to make sure there's something like that that your spouse signs that's says I understand the terms of this option, and that they that they can't be changed, and I understand that my spouse is investing in this and did the due diligence and that type of thing.
Right. But I don't think there's any way to stop, a lawyer from wanting to find out about that option, or why it wasn't exercised, or, whether it wasn't exercised just to kind of screw the spouse. Right. So,
right.
Because it was,
right.
So, I mean, that gets really messy. I don't think a lot of people think about that going in. I don't know if there's a way to avoid it, but it was really a lesson for my client about, how he could get, kind of tied up in the personal relationships of his employees that work for him that he gave options to. So, all right, Leslee. So I think we've kind of covered everything we're going to cover, and we're definitely out of time. But thank you so much for joining me. Are there any last comments you want to share, or do you think you've kind of given all your thoughts on this topic?
I think I've given most of my thoughts. So, but I really appreciate you having me.
Great. I think it's been really helpful. I hope anybody with questions about starting a company where they're looking for investments from outside and need a little bit of guidance on this will give you a shout, and we'll be sharing this obviously so everybody will get to see it. And as always, thanks for joining us on the HealthLaw Hotspot, and we'll see you next time. Thanks so much.
The
Thank
HealthLaw
you.
Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the HealthLaw Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The HealthLaw Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.